No, the point I'm making is a more fundamental point which impacts the future of our country. If you, in principle, say that a parliament can convert itself into a constituent assembly, then where do we go from there? Forget about this case. I'm far more worried about our future. Parliament can never say that, because that constituent assembly is a political process, which I said at the beginning. It's a political process in the context of the aspirations of all those participating in the constituent assembly as to what the state should be like. How do you meet the aspirations of the different segments of the community which have to be met, and what kind of provisions should be put in place? So it's the genesis of the politics of the day which determines what kind of constitution we want. Which is why, when you talk about diversity, when you talk about minorities, we talk about Dalits, we talk in our constitution, what were we faced with? In 1947, what were we faced with? We were faced with a situation where disparate communities, diverse communities, different religions, different races came together to be part of the Union of India, and their aspirations had to be met. So you had provisions with the Dalits, you have provisions with the minorities, you had provisions dealing with reservations, the scheduled castes, the scheduled tribes. That's a political process. That's why our constitution is what it is. Unlike, as I told, in Europe, it was an entirely different process. Here it was an amalgamation of colors to be united as one, which is the Tiranga. That's what it is. You can't convert a legislative assembly into that process.
But equally, Mr. Sibal, to completely divorce the power of amendment from the political process inherent in the amending power,
yes, of course,
would not be appropriate, because there's no strict dichotomy in that sense between the exercise of the constituent power itself being traceable to the political process and the power of a constituent assembly being entirely political in its nature. The constituent power itself of Parliament to amend the Constitution is a political power.
I agree entirely. Absolutely right. We're not saying you can't amend, because it's not our case. You can.
But when Parliament amends according to you, it is not exercising the powers of a constituent assembly.
That's all that I'm saying. That's all that I'm saying. It's not converting itself. And then it has to function within the Constitution of India. I'll come to that later. We're at a stage, Malaz, where a CO is issued.
The Constituent Assembly is untrammeled.
That's right.
It's as if it is working on a clean slate.
That's correct. Absolutely. Absolutely, Malaz. And the judgment says so, Malaz, that it's not bound by anything. Bound by the representatives of the Constituent Assembly who have common aspirations to draft a constitution for the future of the people of the country. Which is why diversity, protection are fundamental to our constitution. For this reason, this very reason. So you want to take away that, that's very dangerous. Now, coming back to Article 368, it may be noted that it has three components. Firstly, it deals with the amendment of the Constitution. Secondly, it designates the body or bodies which can amend the Constitution. And lastly, it prescribes the form and the manner in which the amendment of the Constitution can be effected. The article does not expressly confer power to amend. The power is necessarily implied in the article. The article makes it clear that the amendment of the Constitution can only be made by Parliament, but in cases falling under the proviso, ratification by legislatures of not less than one half of the states is also necessary. Normally, if you read the proviso, if you don't have the ratification, there'll be no amendment. You can't wish away the proviso. That article stipulates various things. To start with, the amendment to the Constitution must be initiated only by the introduction of a bill for that purpose in either House of Parliament. It must then be passed in each House by a majority of the total membership of that House and by a majority of not less than 2/3 of the members of that House present and voting. And if the amendment seeks to make any change in the provisions mentioned in the proviso, it must be ratified by not less than 1/2 of the state legislatures. Thereafter, it should be presented to the President for his assent. It further says that upon such assent being given to the bill, the Constitution shall stand amended in accordance with the terms of the bill. To restate the position, Article 368 deals with the amendment of the Constitution. The article contains both the power and the procedure for amending the Constitution. No undue importance should be attached to the marginal note which says procedure for amendment of the Constitution. Marginal note plays a very little part in the construction of a statutory provision. It should have much less importance in construing a constitutional provision. So, Mullahs, when your lordships talk about temporary, Mullahs, really you have to look at the Constitution. Because it had to be temporary in 1950. There was no element of permanency. It could not have been. And this is the marginal note. Give it to my lord. You have copies?
This is a marginal note. There's no question about it. It is a marginal note.
Yes. So, Mullahs, you can't be saying, which is what your lordships are concerned with, but it was temporary. But that's only when you look at the marginal note. It had to be temporary because there was no other way to deal with it. You couldn't have said it is permanent.
There's no doubt still about the fact that this forms a part of Part 21 of the Constitution, which still deals with temporary and special provisions.
I'm not disputing that. These are all different provisions, Manoj.
They've all been clubbed together in Part 21.
That's correct. But we looked at it in the context of, Manoj, what was going to happen in the northeastern regions. Gujarat and Maharashtra together, what was to happen there, issues of Marathwada. So those councils had to be created, boards had to be created. That's why they were temporary. Telangana, that's why they were temporary. Not for any other reason. And that's why this was also temporary. It's the same logic.